Okay, it's the top of the hour, and we're going to start in just a few minutes. I will also be writing up at least a few of these decisions for you, and of course, for notes from the front members. That means you will also have the documents, the actual Supreme Court documents. If you are a free subscriber and not a paid Notes from the Front member, it's only $5 a month, and that's one of the things you get is those documents. And so I only mention that because in case you want those documents and don't want to have to go and hunt them down yourself, now is a good time to join, and you can cancel at any time. And that way you will have those Supreme Court documents in your inbox sometime today. So, and thank you. I like with that coffee cup too, Teresa. For those of you who don't know, I am a licensed attorney and I also am a law professor emeritus, having taught before I moved from California to Colorado for about 10 years at a local law school in San Jose. So, I also was, for a short time, the dean of cyber law and cybersecurity for that same law school, helping to develop the curriculum. But again, eventually being in Colorado, and that was back in California, made it so that I can't or didn't, it didn't make sense. It's also, in a way, why for anyone who's in Colorado, and I do not mean to make this political, but just by way of explanation, it's how I know Phil Weiser and why I support him and endorse him in his bid for governor here in Colorado, because I've known Phil since the first month I moved to Colorado almost 20 years ago, when originally he was at the local law school here and he interviewed with me, or I interviewed with him, uh, for a potential position, and we've been friends ever since. So, just a little bit of trivia there. All right, give us a few more minutes so you can go grab a cup of coffee or take a quick break. Again, I don't want to have people coming in just a few minutes late and missing any of this. So, and I see people who are hearting this chat. And I really appreciate that because I recently learned that just like every other social media platform, Substack has an algorithm. And apparently, if you hit the heart emoji or, icon on the chat, meaning that you like the chat, then apparently that factors into the algorithm. So I always try to make sure that I am not in any way playing to the algorithm, but there are certain things. So, for example, I will let you know that when you post a link in a comment, and this is true for all of the platforms, that can contribute to that platform suppressing that post. Because, of course, the algorithm doesn't want you telling people, hey, look at this thing over here that's not on this website or platform. So, there's a little trivia for you as well. And I'm gonna just be quiet now so you guys can grab your coffee, grab your cup, grab your seat, grab whatever you wanna grab. We are going to be discussing not only all of the Supreme Court decisions that have made news today, but one that has not made news, at least I haven't seen it yet. So, that'll be sort of an Easter egg for you guys. We are going to be taking the cases, I think we'll do it in this order: the E. Jean Carroll case, the Lisa Cook and Rebecca Slaughter cases, because it's really hard to square them if you followed them at all, but there are things that distinguish them. And then yeah, yeah, that's not true, Chantel. so Chantel is saying that Tom Hartman just released a scary post on how the 6 Trump judges gave him full power of veto over Congress. Absolutely not true, and this is one of the reasons that I do what I do with Notes from the Front, is to dispel all of that social media information, because boy howdy, I bet, Chantel, that Tom Hartman is getting a whole lot of attention from saying that. It's scaremongering, and, ugh, it makes me really it really bothers me. So that is why I always commit to you that you will get from me nothing but 100% facts and truth, and no misleading clickbait at all. And you know what? That's not even just for you guys. That's because that is my integrity. You know, I won't sell my integrity for a few clicks. So, anyway, so then the Cook and the Slaughter decisions, and then the mail-in ballot decision, which is just beautiful, and then I'll also mention very briefly the decision that no one that I have seen has been talking about, in part because it's just sending it back, it's remanding, that's known as remanding it back down to the lower court, but there's one sentence in it having to do with cell phone privacy that I just really want to emphasize. So, okay. Well, let's get started. Good morning, everybody, or afternoon, as the case may be. I am Ann P. Mitchell. I am an attorney and law professor emeritus, and we're going to talk today about the Supreme Court decisions that came out today. And it's going to be a very brief overview of them because, of course, for my Notes from the Front members, I will be writing them all up. Probably one at a time, maybe one of them it will be 2 at a time, uh, in a post where I will also send you all the documents. So the first thing I wanna talk about, is the E. Jean Carroll. It's not a decision, first of all, and as some of you who have been with me for a while understand, when when a case is applied, tried to I have not had enough coffee. Hang on. There you go. All right. When a party appeals a decision to the Supreme Court, they are doing what's called an application for a writ of certiorari, or as we in the legal biz like to abbreviate things, a writ of cert or just cert. So that is a request to the Supreme Court to review the case basically and to review the Court of Appeals, which is the immediately lower court decision. When the Supreme Court decides to decline cert, all that means is that they are not going to review it, and I cannot emphasize this enough. For you guys who have heard me say this before, you're probably sick of it, but a denial of cert is just, "We don't want to review this case." It is not at all a decision on the merits. It has nothing to do with the merits. It's simply the Supreme Court saying, "Hey, we're not gonna take this case and review it." So, with that in mind, today the Supreme Court denied cert for Trump's appeal of the E. Jean Carroll case. That means that the Court of Appeals decision upholding the unanimous jury verdict in that case stands. Now, the interesting question for me is this was in a federal court, so I'm sure you guys can already see where this question is going. The interesting question, and I say interesting clinically, is will Trump pardon himself? It's a federal case. And no president in the history of our country, the 250-year history plus, has ever pardoned himself, at least not as far as I recall. And the thing about this is, first of all, constitutional scholars are divided on whether he actually can pardon himself. and whether you can pardon, a civil case. But the real interesting question is, would he do it? Because he already is so unpopular. And pardoning himself, again, if it's even possible, I'm you know, let's put it this way, even if it's not possible, will he try? And if he tries, what would that do to his ratings? Because I think it would further tank them. So in a way, I kinda hope he tries. But anyway, all that said, that's what is going on with the Supreme Court today with the E. Jean Carroll case. They declined to review it, leaving the Court of Appeals decision and the lower court rulings in place. And I wanted to bring that to your attention in large part because whenever there is a denial of cert in a big case, that, the media, especially misleading social media, just goes crazy and says things like, the Supreme Court allows, you know, the president to be sued for sexual abuse or whatever those clickbait headlines are. And it doesn't allow anything, not in a affirmative way. It just lets it just denies cert, which has the effect of letting that lower court ruling stand. But it is not a decision that the Supreme Court is saying, "We agree with the lower court." So I just want to make sure that is, very, very clear. Okay. So next, we're going to go to the Slaughter and Cook cases. So for those of you who have not yet heard one or the other or both decisions, Lisa Cook is one of the Fed Reserve governors, and she's the one that Trump tried to remove because Pulte pulled up this, perhaps trumped up, perhaps not, more than likely, I would think trumped up, certainly, made her a bigger deal than it is, case that Lisa Cook had lied on her mortgage applications and had been doing some, 2 different residences and that sort of thing. And on that basis, they thought that gave Trump the, uh, the ability to fire her. However, as a Federal Reserve Board of Governors governor, she claimed she is protected by the Federal Reserve Act, which requires that you fire someone for cause. And Trump was saying, well, the cause is that you did this thing and it was fraud. And the case itself was actually about and turned on that she did not have an opportunity to defend herself and to present her case. And the Supreme Court basically said she has to have this opportunity. And that's what the Supreme Court said today. So the Supreme Court said Trump cannot just fire a Fed Reserve governor for cause or without being for cause and without allowing them the opportunity to present their side to see whether there really is that cause. Because otherwise, if that were allowed, it would change the Federal Reserve hiring and firing policies from for cause to at will. Okay, you got that? But then they turned to the case of Rebecca Slaughter, who is an FTC uh, employee, and said the president absolutely has the authority, the overriding authority to fire someone in a federal agency, whether it's for cause or no cause at all, essentially at will. Now, it's how do you square these two things? The Supreme Court did a whole lot of contortions in order to square them, and basically it came down to this. The Federal Reserve was created and is under the Federal Reserve Act. All of the other agencies are under various other federal laws and acts, like the civil I forget exactly what it's called, but I have it highlighted here, but there's the Civil Service Act of 1978 is what I think it's called, which says that anyone who is in any of the federal agencies can only be fired for cause. There are also a lot of different acts creating these agencies, which also say, you know, people it has to be fired for cause. You can't just at will fire someone. The Supreme Court said in the Slaughter case, which overturned guys may have heard of this lawsuit or this case called Humphrey's Executor, which was decided in 1935. It was a unanimous decision, and it has been the guiding law ever since, which basically says federal employees have to be fired for cause. They can't be, you have to explain why you're firing them, whether it's for malfeasance or some other cause. And Humphrey's Executor has been being chipped away at for ages. And what the Supreme Court said in today's decision was that basically Humphrey's Executor was already almost dead and that it was basically impermissible and unconstitutional to limit an executive's authority to hire and fire who he wants to work with. And they also said that where Congress gets involved is Congress can either, approve or not the the proposed federal employees that the president puts up and nominates before Congress, right? Congress either, there's a nomination and then they either can, approve it or not. And that's where Congress's authority over these people ends because at that point, you can't saddle the president with someone with whom he can't work. And so, therefore, he needs to have the authority to fire someone without having to jump through a lot of hoops and contortions in order to explain why. In other words, for cause. On the other hand, the Federal Reserve, says the Supreme Court, is a different animal, and we have to protect it. For one thing, the for cause clause of governing Lisa Cook, the governor of the board on the Federal Reserve, that clause is in specifically the Federal Reserve Act. So they distinguish it slightly just by that. And then they go through our entire history of federal banks, explaining that ever since the founding of our country, again, 250 years ago, the federal bank, when there has been one, because for a little while there wasn't one, but the federal bank has always been essentially untouchable because otherwise it would be untenable to have the executive able to fully control the Federal Reserve and therefore, influence interest rates and that sort of thing. And for the legal people who are in the chat right now, they even invoke McCulloch v. Maryland, which for you non-legal people is one of the very first cases we learn about in law school on almost day one. So this doesn't mean Lisa Cook is out of the woods. It means that she is going to get an opportunity to present her side of the case instead of just being fired. So if you're still left scratching your head wondering, like, how did they really distinguish it? You know, you're not alone because their distinguishing characteristics between each case were basically we want to give the president this power, but we don't want to give it to him over the Fed. So so that's basically how that squares. So if you're confused still, again, I understand that because it's a pretty fine line that they were walking. On the other hand, as I often say, As lawyers, we have degrees, advanced degrees in hair splitting, and you don't get to be a judge, especially to the Supreme Court, unless you are really good at hair splitting, and that's what's happened here. Okay, I'm gonna stop and take a sip and, see if I see any questions. Okay, good. Okay, I'm just looking. I just wanted to thank you for allowing me that sip and a quick check. Okay, now we are going to turn to the mail-in voting. And what this case was the state of Mississippi. Now, you may be surprised at the caption, and again, the caption is the section of the lawsuit that says who the parties are and where what which court, etcetera. And you may be surprised to find what traditionally people might think of as one of them down south states, Mississippi, as the plaintiff against the Republican Party. But that those are the parties, the state of Mississippi versus the Republican Party. What this case was about was the state of Mississippi has a law that says as long as your ballots are postmarked by election day and received within 5 days after election day, they will be counted. And of course, as we all know, the Republican Party, the party of Trump, was trying to, is trying to do whatever it can to limit, if not completely obliterate, mail in ballots. So, what the court said about this, and I'm going to give you a couple of quotes. First of all, to just cut to the chase, the court said that Mississippi's law is fine. Now, I don't know whether there are other states that allow mail-in ballots to be counted more than 5 days, but this particular case was 5 days. And the court said, first of all, the administration and the Republican Party was basically saying, well, federal election day statutes, they preempt Mississippi and state law because, it's the federal government. And of course, as we have said over and over and over, in the Constitution, primarily the states get to administer elections, even federal elections. So here the court says that federal statutes don't preempt state law because, quote, "The defining element of an election has always been that it is the electorate's choice of candidate." And what they're saying is that the election isn't over until the electorate, we the people, choose the candidate. And of course, the choosing of the candidate is in the counting of the ballots. And they go on to say, quote, "While federal law dictates when ballots must be cast, state law governs when they must be received." In other words, yes, the federal law sets the date of election day, but it doesn't get to say when those votes get counted. And finally, the court says, again, quote, "The electorate's, in other words, we the people, the electorate's choice is made when voting is complete, not when ballots are received." And with that, they just basically upheld mail in voting and the counting of ballots that are as long as they're postmarked by election day. And I think Trump probably knew that the handwriting was on the wall with this one, which is why he is still pushing so hard to have the SAVE Act passed, which is not going to happen. And I've been telling you since the moment that it was introduced, it's not going to pass. And I think now you're seeing that it's again, it's just not going to happen. And I think again, this may be why. And relatedly, as you know, that bipartisan housing bill that Trump originally said he would sign, and then he held back and said, "I'm not signing this until the SAVE Act happens." I just heard yesterday that Mike Johnson, is going to send that bipartisan bill to the president, and that he thinks the president is going to sign it, but that if he doesn't, unless he vetoes it, it will still become law in 10 days because that's how that works. So it's all tied together, but that is the mail-in ballot law. Now, the USPS they've actually already said that they're promulgating rules that will inhibit mail-in ballots. I said the day that they said that I was confident that it would go to court, and now that has already gone to court. And I believe that the courts will strike that down. They'll say, "No, you can't do that." And this decision by the Supreme Court just gives them extra teeth to do that. Okay. The last thing that I wanna talk about very briefly is the one that I said I haven't even been seeing it on any of the media, or I haven't heard about it on the radio, so it may or may not even have come to your attention. But there's a case called, hang on, I'm looking it up, Chatri versus United States. And it is a case that came up because a guy robbed a bank or a credit union, and one of the things that the police did was they took his phone, or they otherwise accessed his phone records to access his location information to place him at the scene. And the court issued this decision also today. And again, I haven't heard or seen anywhere reporting it. And they basically sent it back down because there was a whole bunch of procedural steps. So they sent it back down to the lower court to basically pick apart and determine whether the Fourth Amendment had been violated in any of the steps. But the thing that I wanted to bring to your attention is that the Supreme Court says, and now I am quoting, let's see, hang on, that the Fourth Amendment gives an individual, and they were getting the location data from Google, they were going after it from Google. The Fourth Amendment gives an individual a reasonable expectation of privacy in his cell phone location information. So this is the Supreme Court coming right out and saying, "You know what? Cell phone location information, that is protected by the Fourth Amendment, and you can't get it, law enforcement agencies, unless you go through the correct procedural steps and you get a warrant and you do everything that you have to. You have to establish probable cause. You can't just willy-nilly ask Google to turn over someone's location information." So I don't know, has anyone else, seen this being reported in the news? Okay. Glenn says that he heard about it on other legal discussion shows, but not I haven't seen anyone that has heard about it in the news. Okay. Always turn off your location history on Google. Okay. Anyways, I am going to, of course, as I said, be writing these up. And for Notes from the Front members that are the ones that, pay the $5 a month to get the documents and other perks, you'll be having these decisions also direct from the Supreme Court in your inbox. I probably won't send or even write up that one about the location information. I might, but it's almost a throwaway line in the opinion. So we'll see. And of course, I won't be writing up the E. Jean Carroll case because there's nothing to write up. It was a denial of cert. It was not an opinion. And that's it. Thank you guys so much for joining me, and have a wonderful start of your week. Bye for now. Oops, one other thing. The recording of this, of course, will be available to you guys shortly. Okay. Now I'm really going. Have a wonderful day.